Welcome back. Now, wrapping up a deceased estate can be an emotional and complicated process, especially when there are kids involved. A Finweek reader recently asked how she can stay in control of her late ex-husband's estate to ensure that her children's needs and education were taken care of. We are joined now by Arnold Shapiro, director at Routledge Modise, and Johann van Rensburg, managing director of the Executors, about our readers' options. Gentlemen, thank you so much for joining us. Before we get into some of the questions that readers have sent through, perhaps let me first come to you, Arnold, and ask, following the passing of a spouse and assuming one that you're married to at this stage, what is the first order of activities you should be doing?
Right, when one passes away, their estate is frozen. I would imagine the first port of call would be to consult an expert for advice and guidance on the administration. The estate needs to be reported and a procedure needs to be followed. I'm hoping that one would put their affairs in order before the person dies and have a lifestyle file where wills and letters of wishes and important documents would be contained.
So there's that thing called a lifestyle file that I obviously don't have. And Johann, I'm quite sure there are a number of South Africans who don't have lifestyle files. Talk to us about, when we should, how do we make sure that we have these things in place? And do you find in general that those sort of personal affairs are not actually in order?
Well, according to some statistics that I got from the Master of the High Court some time ago, it's said that about 80% of the public either do not have a will or do not have a will that is up to date currently. I want to agree with Arnold to say that you need to look at your will at least once a year, revise it, and make sure that there's enough liquidity in your estate, because unfortunately it's expensive to die. There's costs that need to be paid, and if there's no money to pay, it's very difficult to resolve an estate.
I'm a young guy. I'm not thinking about dying anytime soon, and those files don't exist in my life, and I'm sure to a lot of South Africans as well, it doesn't exist. What happens in that case if one passes and those files simply don't exist, or maybe their affairs were not, collected and put into order, as you put it, Arnold?
One of the criticisms of administering an estate is this time taken. And the more ordered your file is, the quicker one can administer it. Don't make it a treasure hunt for people who don't know you and your affairs. They've got to sift through reams and reams of documents, your financials, your bank statements, and try and uncover the assets. By putting it in order, you ensure order and dignity to the administration at a later stage.
Johann, I have a question for you. You mentioned that there are costs involved in settling your estate. Can you tell us a little bit more about that?
Yeah, the cost for the executor itself is 3.5% plus VAT, which is roughly about 3.99%. And the other cost involved would be if there was any property that needs to be transferred, and as well as the advertisements that has to be placed in the government and set in the local newspaper where the person actually resided at 12 months before.
Would that be 3% of the estate?
3.5% of the gross estate, yeah.
So do you pay tax on transferring property on a deceased estate?
No, not according to my knowledge.
What happens is you pay the transfer costs of transferring immovable property, but the government waives its charge on transfer duties. So there's no transfer duties.
So it's actually just the legal fee of the attorney that does the transfer on behalf.
Realistically, how long does this process take? And maybe come to you, Arnold, on that.
It's a good question. There's no time frame. There are practical problems. So even with the most competent person, there could be difficulties where there could be a dispute. A child comes out of the woodwork and says, this is my father. There's a relationship and one needs to determine the consequences of it. Is there a customary marriage? Isn't there? But an estate should be wound up within a period of a year. I think the L&D should be lodged within a period of 6 to 8 months, unless there are reasons, justifiable reasons. In terms of the Act, one has 6 months from the date of the grant of letters of executorship to submit the balance sheet or liquidation account to the
Let me
master.
latch on to that question and perhaps read one of the questions that have come through from the reason. Maybe, Johann, you can take this one on. Okay. This reader says, what legal angle would you suggest where I, as the remaining parent, have power to what happens to and what belongs to my children without having me to go through the deceased mother?
Well, okay, first of all, let's just clarify, is it a lady that has power over children currently that are minors, that where her husband most probably have died?
Yes.
Look, the first thing that needs to be clarified is if there was a will in place. If there was a will in place, it would be very easy for her to see who has appointed the executor of the estate. If she cannot find any documents relating to that, she can go to the master's office with a copy of the ID of the deceased husband, and then from there they will assist her with a file at which master's office it was lodged. But the mother of minor children always have a right, because the minor children do have a claim against the estate for maintenance if they're still minors.
Arnold, I have a question for you. What if you are, say in this lady's case, what if she was dependent on her husband's money and the estate gets frozen? Is there a way for her to then get money and get support through this process?
It's a good question. It's a very practical question. The Administration of Estates Act is the most practical bit of legislation. It takes cognizance of the tragedy of somebody passing, and it gives dignity to their affairs without creating further burdens. Number one, the Master's Office, within a period of a week, you should obtain your letters of executorship. So where you told the estate's frozen, it's unfrozen within a week. Number two, there's a specific provision in the Act that the executor can make interim payments to provide for the subsistence of the family and household. Number three, the Act tells you by when you must make payment, but it doesn't prohibit an earlier payment. So there really are safeguards.
This process, to my mind, includes a lot of emotional roller coaster. This woman has just lost her ex-husband or husband. There's a lot she has to deal with emotionally, with the kids as well, etc., etc. Can she appoint someone and say, I've got a sister who I can appoint on my behalf to actually go through all these activities that need to be done, instead of me as someone who's grieving, going through all these emotions?
What happens is that letters of executorship are granted to a person who accepts the responsibility for administering the estate. They have the right to appoint an agent. And as long as they appoint an agent who's competent and an expert in the field, the administration should flow. There are advantages to having a member of family as the executor and allow them then to appoint an agent. Just to name one or two, they've got a right then to appoint an agent of their choice. If they become disenchanted with that agent, they can terminate the mandate and appoint another. Whereas if you're an executor, you're entrenched. They can negotiate a fee. The executor's fee is fixed by tariff for the executor, not the agent. And there are other various advantages whereby they have a right to be in control, to deal with the estate. I think psychologically it assists them in bringing closure to the matter, and they're not sidelined. And if they do become disenchanted, they can sideline the agent. And
let's look at the trend of bequeathing your estate to a trust. Why would a person opt to do this?
You must understand that a trust is normally a conduit for distributing income. So a lot of times people used to make use of the 3.5 million deduction to make sure that it goes to a trust, to make sure that the beneficiaries of that trust are looked after. I normally advise people rather to stay away from a trust unless some of the kids are really disabled or they're physically handicapped and they really need somebody to guide them with that. The money in the trust, to make sure that it works as a conduit for them for an income.
I must say that, I'm trying to think practically, especially in an African situation where the concept of family is very murky, and you have cousin sisters and cousin brothers, as the Xhosa nation would have. But in essence, you have family isn't always about mother, father, children. It's mother, father, and everybody else. In a situation like that, how should one go about making sure that there's no misinterpretation should the lead breadwinner in that particular structure pass on?
during our lifetime, we're fastidious about our affairs. We have our finger right on the pulse and we are organized. The world gives that dignity to when you're not there. And that's the only word of advice I can give it. The quotation is, it's the most important document you can ever prepare in your life. And see an expert and prepare a proper will, because it's your constitution that provides for the orderly distribution of what you've spent your life accumulating to ensure that your Nyar and Dear ones receive what you wish them to receive.
What can you do in a situation where, as you said, Nazipa, where the structure is different and you are the mother of the children of the person who passed away? Is there a way that you can protect that the money you get from the estate to make sure that it goes to your children and not to, say, other grandchildren in the family?
Yes, there is. The Wills Act gives you alternatives. Number one, so it's always sad because lawyers put in big words or Latin and it makes us sound educated, but our common law is Roman Dutch, and for that reason there are a lot of legal terms. You could create a usufruct, you could create a fideicomissum, in terms of which you would bequeath the estate to A, providing on the happening of an event, the estate then goes to B. So you can ensure that there's a continuity. The other alternative could be a trust where you have perpetual existence of the trust providing for beneficiaries over a period of time.
Unfortunately, it does sound a bit arbitrary that I'm going to say that this the time is up, but given the fact that we're talking about such a dark and gloomy topic, but it is exciting to understand the intricacies and how one should navigate that space should